So moving on to the next podcast, this is part B of the overview of the three certainties. We've seen that we need three certainties to create and express trust. There has to be an intention to create trust. The property, the subject matter of the trust, needs to be clear, and the beneficiaries also need to be clear. So we need to kind of take a step back and ask, well, surely we can just write this all down. Who the beneficiaries are, who the trustee is, what the property is. And that is certainly the ideal, that we go to a lawyer, we get something called a trust instrument drafted by them based on them asking us a list of questions. And you can go to a database like Practical Law or LexisNexis, PSL LexisNexis, and you can see a typical pro forma of the type of questions that a lawyer will ask their trustee. There would be trustee, or there would be settler, or there would be beneficiary. So these things are worth looking at, and in practice that's what you would ideally want. But there are two problems with just relying on people going to set up a trust through a lawyer, and the trustees and the beneficiaries also getting legal advice. The first is that equity is concerned with doing justice. So a trust exists even if the parties are unaware of it. And I've already in previous podcasts talked about Paul and Constance, and I'm going to talk about it later on in certainty of intention. But just to note that there you had people who didn't go to a lawyer. There were just circumstances that added up to the creation of a trust. And that trust, the courts did not imply a trust lightly, but they said there's clear evidence here that the person who was taken to set up a trust had done so with a clear intention to divide the title between two people, himself and his girlfriend, if you remember the example. So that's one problem, that a trust, if it quacks like a duck, looks like a duck, waddles like a duck, it's a duck. So a trust is a kind of objective state of affairs, and it doesn't really matter whether people know it's a trust, if they use the word trust. As long as it amounts to a trust, the courts will enforce it. So yes, a trust instrument is the best way of doing things, and the most likely way of doing things in practice, but there are circumstances which will amount to trust, so you need to know what these three certainties are. There are some lecturers out there that will skip through the three certainties very quickly. That's a mistake, because if you're going to be, for example, a practicing lawyer in the area, whether just drafting the stuff or dealing with contentious probate, you need to know what the default law is, because otherwise you're drafting something in ignorance of what the default would be if you hadn't drafted a particular instrument. The second point is that actually even successful business people may unwittingly create a trust. And again, I'm going to talk about this case a bit later on, but that's just the basic point. And it follows from the first one about doing justice that, if it quacks like a duck and if it walks and waddles like a duck, it's a duck. Likewise, if you create a business structure where you have split the ownership but you haven't called it a trust, the courts will look at what your objective intentions were, not your subjective intentions, your objective intentions. So it may amount to a trust whether you wanted to expressly or not. So I think that's a good sort of launch pad into looking in subsequent podcasts at each of the elements of the three certainties, now that we know in overview what they are, intentions, subject matter, and objects, and seen why we need to know this. It's not just a question of going to a lawyer, getting a trust instrument sorted out. That's the ideal. That's what you would do if you knew what a trust was to begin with. But life being more complicated, even business people and normal, if you like, non-business people can do stuff that amounts to a trust. And that's why we need to know what the three certainties are. Hope that's useful.